Good morning, this is your Kelso Report for Thursday, September 20th. I'm your host, Clark Kelso. We have two cases today, the first involving rules that require district courts to provide some assistance to pro se prisoner litigants in the context of certain pretrial motions. And our second case involves limitations placed on local government in California using the power of eminent domain, where a property owner loses access to public roads and becomes landlocked. We begin with the Ninth Circuit and prisoner litigants. Now, there's an old saying that he who is his own lawyer has a fool for a client. But if you are an inmate in prison and indigent, you really have no choice but to represent yourself, even though self-representation in complex civil or criminal proceedings is an extremely difficult task for someone who's not educated as a lawyer. The plaintiff in Stratton v. Buck had been assaulted by a fellow inmate at a corrections center. While then being held in a protective custody holding cell after the assault, a registered nurse asked Stratton, "What hurts? What happened? Are you in pain?" Shortly thereafter, after transport to an emergency room, a doctor examined the inmate. Well, in his subsequent lawsuit, the inmate alleged that the nurse and doctor failed to provide pain medication, and that violated his 8th Amendment right to be free from cruel and unusual punishment and his 14th Amendment right to due process. The defendants in the case filed a motion to dismiss for failure to exhaust administrative remedies, which the district court granted. On appeal, the inmate complained that no one had explained to him the requirements for responding to a motion to dismiss for failure to exhaust, and in particular, that the district court could consider material outside the pleadings when ruling on a motion to dismiss for failure to exhaust. Well, the Ninth Circuit agreed with this point on appeal and reversed the dismissal. The Ninth Circuit precedent had already held that a pro se prisoner litigant is entitled to fair notice of the requirements and consequences of a summary judgment motion. So it was a simple step to extend that approach to this case involving a motion to dismiss for failure to exhaust. So in particular, the court held that when a district court will consider materials beyond the pleadings in ruling upon a defendant's motion to dismiss for failure to exhaust administrative remedies, the pro se prisoner plaintiff must receive a notice explaining that the motion to dismiss for failure to exhaust is similar to a motion for a summary judgment in that the district court will consider materials beyond the pleadings. The plaintiff has a right to file counter affidavits or other responsive evidentiary materials, and it will describe the effect of losing the motion. Finally, the notice must be phrased in ordinary, understandable language calculated to apprise an unsophisticated prisoner of his or her rights and obligations under Rule 12. Bottom line, you have to help out the pro se prisoner litigant get through some of the technicalities of those early pretrial motions. Now we turn to eminent domain under state law. The process of eminent domain by municipalities is subject to certain statutory requirements and limitations. In particular, a local government body must make a finding of public necessity to support its use of eminent domain, and it can make that finding only if it concludes that the public interest and necessity require the project is planned or located in the manner that will be most compatible with the greatest public good and the least private injury, and the property sought to be acquired is necessary for the project. One additional limitation applies when the use of eminent domain affects a landowner's access to roads, and the proper interpretation of that limitation was the issue in Council of San Benito County Governments versus Hollister Inn. The project in this case resulted in the elimination of a roadway easement over private property that connected the Hollister Inn's property to Highway 25. although the Hollister Inn still had access to a different road on the other side of its property. The Hollister Inn protested the elimination of its preferred access to Highway 25. The Superior Court held that the local government entity had grossly abused its discretion by eliminating the Hollister's roadway easement, and it required alteration of the project before the court would permit eminent domain to be exercised, and it awarded Hollister $250,000 in attorney's fees. The 6th District reversed. The applicable statutory language was triggered only if Hollister's property was, quote, cut off from access to a public road as a result of the acquisition by the public entity, close quote. The 6th District held that this language required the affected property to become entirely landlocked before its restrictions were triggered. As the court noted, Hollister's property still had, quote, access to a public road, close quote, after the acquisition, just not the public road that Hollister preferred. Given this interpretation, the 6th District held the local governing body did not abuse its discretion, and the Superior Court should not have awarded the attorney's fees to Hollister. The bottom line here is that the Hollister Inn is left with less than ideal access to Highway 25 through a public road on the other side of its property, since the government entity is not required to supply Hollister Inn with a substitute access easement to Highway 25. Its access to the other public road is going to have to be good enough. That's it for today's Kelso Report. Have a great day in the law.